Hello, everyone. Welcome to another session of ILA Dialogues. Today, we have with us Advocate Nakul Sharedalal. Nakul is the founder of NS Legal. He's a master. He's a master of laws from Queen Mary University of London. He has specialized in commercial and corporate law, where intellectual property formed an integral part of his curriculum. He has been into law practice since more than a decade now and advises the domestic and international industry across all spectrums of intellectual property issues. His expertise dwells into advisory opinions, filing IP applications, handling settlements and mediations, drafting of documents, preparing IP strategies, and arguing matters before tribunals and courts. Apart from his professional commitments, he loves to educate and enlighten his fellow countrymen and statesmen about intellectual property. After pursuing his Masters of Law, he specially returned to India from Great Britain to further his ideology of making his country ever ready in IPR. He's a regular speaker at various apex bodies and educational institutions. Having an extensive IPR legacy behind him, he believes in spreading awareness by stimulating the innovators and creators to nosedive into the world of IPR. Welcome, Nakul. Nakul will be speaking on IPR perspective today.
Thank you, Sudisha, for such a kind introduction. I'll begin my presentation right away.
Sure.
So I'm going to present on trademarks and its perspectives. I'm going to talk about its aspects and how does it affect, how do the aspects affect in the real world, which will help you to understand the concepts of trademarks in a much better sense. So the idea of intellectual property dates all the way back to 500 BC. It came about because the Greek state of Sybaris allowed its citizens. Uh, can all of you see the presentation?
I can't see the presentation.
Okay, so let me once again.
Yes.
Yeah, can you see it now?
Yes, yes.
Okay, okay. So it came about because the Greek state of Sybaris allowed its citizen to obtain a patent for any new refinement in luxury. Since then, refinements have been made, but the intent of laws has always remained the same. The laws are created to encourage people's creativity and make it possible for inventors to reap the benefits of their original ideas. The term intellectual property can be found used in an October 1845 Massachusetts Circuit Court ruling in the case of Devil versus Brown, in which Justice Charles Woodbury wrote that in only in this way we can protect intellectual property. The labors of the mind, productions and interests are as much a man's own as the wheat he cultivates or the flock he rears. Trademarks only help distinguish products within the legal and business systems, but just as significantly with the consumers. They are used to identify and protect words and design elements that identify the source, owner, or developer of a product or service. They can be corporate logos, slogans, brand name of a product. Similar to a trademark, a service mark identifies and distinguishes the source of service rather than a product, and the term trademark is often used to refer both the marks. Using a trademark prevents others from using a company or individual's products or services without their permission. This means that a business cannot be use a symbol or a brand name if it looks or sounds similar or has a similar meaning to one that's already on the books, especially if the products or services are related. The use of trademark dates back thousands of years. The first marks, the branding of livestock depicted in Stone Age cave paintings, identified personal property to prevent theft. Egyptian masonry from some 6,000 years ago shows quarry of marks and stonecutter signs, which named the source of the stone and the laborer who carried out the work. The practice of marking goods with a graphic design to certify its origin and quality spread throughout the ancient world as the scale of commerce increased and goods became more sophisticated. Some of the marks used by trade guilds in the Middle Ages, such as the hallmark for gold purity, are still in use today, although the guilds no longer exist. Over the years, these marks evolved into today's system of trademark registration and protection. The earliest trademark legislation was the Baker's Marking Law, obliging every baker to put his mark on the bread he baked, enacted by the British Parliament in 1266. Merchant marks and personal marks used from 13th to 16th century could be considered the predecessors of modern trademarks in that they bore the names of the traders and served as a guarantee that the goods sold were of the expected quality. A trademark is a symbol, word, uh, or words legally registered or established by use um, as, as representing a company or a product. It identifies goods or services. It guarantees its quality. It advertises the goods and services, and it creates an image for those goods and services in the mind of the receiver or a consumer. There are various marks. There are various types of trademarks, being generic mark, suggestive mark, descriptive mark, arbitrary mark, and fanciful mark. Generic marks represent the everyday descriptions of a product or its seller. This could be common words such as shoes, watch, or food. But since these words belong to public, for instance, cannot register a trademark for the term ice cream for ice cream parlor, right? The suggestive marks register words that imply qualities of a product without necessarily relating to it in a literal sense. Imagination from the consumer's end is a primary consideration in classifying a mark as suggestive. A good example would be Netflix, as it alludes to its line of service without directly stating that it is an online streaming platform. Descriptive mark, while the generic mark may represent a product or its provider, a descriptive mark applies solely to the merchandise. But since these words are considered part of the universal language, they are still non-registrable. Arbitrary mark pulls words or phrases from the vernacular. However, these words should be entirely unrelated to the products they signify. So the caveat then comes the increased cost of advertising strategies, like Sun is used for microsystems, Camel is used for cigarettes, or Apple is used for iPhones. All these are arbitrary marks because they are not directly related to the products they are sold for. Then comes the fanciful mark. This kind of trademark is indeed the easiest one to register. It only requires a new word that does not presently hold any meaning to the general public. Once registered, a trademark, like we all know, is valid for 10 years and it's renewable at the end of every 10 years. Trademark registration in India helps in propelling a business venture or company in many ways. It also gives an exclusive right to the manufacturer to secure its brand and exclude all others from doing so. It also helps in a case an infringement occurs because the statutory right then steps in. The premise of trademark protection is that no man is entitled to sell another's brand under the guise that it belongs to him, and the goal is to protect the owner and the consumer in case of any deceit or confusion. So this is uh, uh, you apply this when you write this when you apply the trademark and it's under registration process but not registered. And when the trademark is registered, you remove the TM and put a R on the top right side of your trademark. So the trademarks registration office opened in London. The first registered trademark in UK was that of a beer company called Bass and Company, applied for on 1st January 1876, which is still valid. We could not trace the first trademark that was registered in India. However, the earliest trademark traceable in trademark registered in India was trademark number 10, which is granted by Kolkata Trademark Office on 1st June 1942 for the mark black and white to James and Buchanan and Company Limited. So every business will have some form of intellectual property, and it is not just limited to those that deal with technology. To appreciate the importance of intellectual property, it is necessary to understand the nature of different intellectual property rights, what they protect, and how the rights can be obtained and how they best can be commercialized. Licensing is a major aspect of intellectual property. A licensing agreement is a partnership between an intellectual property rights owner known as the licensor and another who is authorized to use such rights known as the licensee in exchange of an agreed payment known as royalty. The intellectual property assignment is a transfer of an owner's right, title, and interest in certain intellectual property rights. One can license, sell, or franchise their intellectual property and earn out of it in a significant way. The recent example of such an assignment is a big ice cream company where it earned 90% of its deal value from the Korean giant out of its intellectual property. And then the successful franchising examples are always Nike, Subway, and McDonald's, which are very famous for their successful franchising models. So quality control is very important when you're commercializing your trademarks. If you do not commercialize, if you do not have a proper quality control, it can result in naked license of your trademark. So a naked license is a license under which a licensor allows use of its trademarks by a licensee without incorporating quality control provisions in the license agreement and or enforcing such provisions. Broadly speaking, this leads to undesirable consequences for consumers who, without their knowledge, are deprived of implicit assurance that products emanating from the licensee are of the same quality as those emanating from the licensor. It does not end here. Additionally, additional consequences may unravel for the licensor and licensee as their ability to enforce rights against third-party misuse of trademarks could be seriously compromised. Ultimately, the licensor stands potentially to forfeit or abandon its rights to the trademarks in question as these no longer function as the trademarks as they do not consistently indicate origin or goods and the assured quality of products or services thereunder. In the case of Gujarat Bottling Company Limited versus Coca-Cola, the Supreme Court held that the license of a trademark without the registration of licensee would be governed by common law. It was also held that an unregistered licensee could validly use the trademark on fulfillment of three conditions of not causing confusion or deception to the public, not destroying the distinctiveness of the trademark in the public, and maintaining a connection between the proprietor and the goods under the mark. So, trademark licensing agreements enable businesses to expand into new horizons and enter new markets by connecting with multiple registered users. It is imperative that when enforcing such license agreements, the trademark owners include adequate quality control provisions to control the reputation of the brand name. The goods or services hailing from the registered user must be duly supervised and inspected by the trademark owners to maintain the status quo of their brand. So, quality control plays a very important role in representing the standing of brand associated with the business and its reputation. So, trademark audit is very important. So, the audit of a trademark portfolio goes a long way. It basically a trademark audit ascertains the robustness of a brand's trademark portfolio. All brand owners should consider having their trademark portfolio audited periodically. A trademark audit conducted by an experienced trademark agent examines the current status of the brand owner's trademark portfolio to ensure its holdings accurately and adequately protects the brand owner's interests. The trademark landscape is constantly evolving, so it is important that trademark portfolio evolve with it. Unregistered trademarks with prior use can be protected under common law in India. The passing of trademarks is taught actionable under common law and is mainly used to protect the goodwill attached to unregistered trademarks. It is founded on the basic tenet of the law that one party should not benefit from labor of another. Various judicial decisions have established that a passing of action is a misrepresentation made by a person in course of trade to prospective customers of the manufacturer or the ultimate consumers of the goods or services that it supplies to. Um, because it creates it because it is done to which is calculated to injure the business or goodwill of another party, which causes actual damage to the business or goodwill of a party which has brought or is likely to bring the action. So, in a typical passing of suit, the courts will generally consider the following issues: whether the plaintiff is a prior user of the mark, whether plaintiff goods have acquired distinctiveness, and whether there is a misrepresentation by the defendant with regards to the goods such that the plaintiff is using. Now we'll discuss statutory right. A registered trademark is infringed by a person who, being a registered proprietor, or a person using by way of permitted uses in the course of trade a mark which is identical or the trademark in relation to goods or services in respect of which the trademark is registered. So the following issues will arise in a suit of infringement of trademark. Uh, the court will ask the following questions: is the plaintiff entitled to file a suit um, in the capacity of being the owner of the mark? Does the trademark subsist in the scenario alleged to have been infringed? Does the defendant does what the defendant has done constitute infringement of a trademark? And thereafter, there are there are two types of remedies that are available in such a case. One is an action of infringement in case of registered trademark, and an action of passing of which we already discussed in the previous slide as per the common law remedy. So I'll very quickly discuss section 9 and 11 because it's absolutely imperative as the heart of trademarks at the tribunal to get hold of these sections. So section 9 discusses absolute grounds of refusal of the Trademarks Act, and they are as below. The trademark is devoid of any distinctive character, that it is not capable of distinguishing the goods or services of one party from the other. The mark consists exclusively of the marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, etc. Of the goods, or rendering the service or other characteristics of goods or services. The mark consists exclusively of marks or indications which have become customary in language or established practices of trade. The mark is of such a nature as to deceive public and cause confusion. The mark comprises material likely to offend religious class or a section of the citizens. We'll see, one example, one global example to this point later on in my presentation. The mark comprises of scandalous or obscene matter, and it is prohibited under Emblems Act of the country. So these are the absolute grounds of refusal in a nutshell. Now we'll see relative grounds of refusal, which are recorded under section 11, under which your trademark will be refused because of the following that I am about to say. That a mark cannot be registered if there is a likelihood of confusion due to its identity with an earlier mark, or similarity to an earlier mark, or it's identical to an earlier mark along with the goods and services, right? So such a mark cannot be registered, and the registry will call for an explanation by issuing an examination report and raising an objection to the application which is made where an earlier mark is found on the register which is similar or identical to the application which has been currently made. So this is section 11, which discusses relative grounds of refusal. So this is a normal course of trademark process. You apply, you get your trademark registered after following the due process at trademark office, which takes about 10 months now, just under 10 months. And after registration, you are free to oppose the mark, which you find is similar to your mark. Opposing a mark is available in a trademark journal. When a trademark journal is published, it's published periodically. You need to keep observing the marks that are published in the trademark journal, and the ones that you find similar to the marks of your client, you obviously oppose those marks because they are similar to your client's mark and they are used for the same product or services. So then there are a number of Supreme Court judgments and various other High Court judgments that will come to your rescue, apart from trademark office orders, and such marks cannot be registered. And I think if you have a case where there is a mark which is similar and is used for identical products and services, your opposition is most likely to succeed. So it's very important to understand this concept where while you make an application, you need to understand why you need to have an user date, and if you do not, then it's called proposed to be used. So proposed to be used applications are much weaker because dealing with objections raised by the trademark office under section 11 will be much difficult to get through because you have not used the mark at all, and therefore you have nothing to prove in your claim of registration of your mark. However, fanciful marks with proposed to be used criteria are easily allowed because the fanciful marks most of the times do not find any confusing or identical or similar marks on the register. However, if you have an user date, which dates back to few months or a few years, then you know uh, you have to take it. You have to establish that by way of an user affidavit, and you have to annex various commercial documents to that effect, which prove that in fact you are using this trademark from that particular user date, and therefore the trademark office should grant that date to you, even when your application is much subsequent to the date of use. So now I'll directly come to a few case laws that I'm going to discuss today. I think these are the case laws that I have found very interesting. Some have been settled, some are pending, and some have become landmark judgments. And I would be very happy to discuss that with all of you. So first is I like this case very much. It's Britannia versus ITC, and ITC filed a suit against Britannia Industries for passing of an infringement of trade dress of ITC's product Sunfeast Farmlight All Good, which is a no added sugar and no maida digestive biscuit. So as per ITC, Britannia's product NutriChoice Digestive Zero, which was also a no added sugar and no maida product, had a packaging which was deceptively similar to ITC's product packaging of Sunfeast Farmlight All Good. Um, both the products were being sold in a color combination of blue and yellow. So the learned single judge at the High Court of Delhi granted a temporary injunction in favor of the respondent on the following terms: that when a new product with a distinctive uh, packaging is introduced, it is not necessary for the plaintiff to show that it has established a formidable reputation. The factum of sales of 5 crores was a significant factor in examining the question of reputation of a product, as also the factum of 14 crores, which was spent on advertising. Britannia had been late in introducing its Digestive Zero after 6 months since ITC introduced the product, and that weighed in favor of ITC before the single judge. And mm, uh, you know, even if the learned single judge was to accept that yellow as a color was integral to Britannia's packaging for digestive biscuit, Britannia's purpose could well be served by adopting a color other than blue to combine the yellow color of its packaging. That's what the judge said. However, ITC filed and went to the division bench, of course, and division bench then ruled, made the following observations. Britannia has been restrained from using the color blue. It has been permitted to retain the color yellow. In other words, the entire controversy in the present case centers around the use of blue and or its variants in the packaging. It is therefore clear that in case of uh, Britannia uses the same packaging, but substitutes the blue with any other color, then there would be no case for passing off. Then it went on to explain the passing of action, where it said that it is evident that a passing of action has to be examined from the standpoint of three factors: goodwill and reputation, misrepresentation, possibility of deception, and finally third, which is likelihood of damage. So ITC, in order to succeed, had to establish that combination of yellow and blue is used in its packaging and has become distinctive. However, ITC could not establish that because its period of sale was just 6 months, and Code refused to buy that within a period of 6 months. Because of the sale of 14 crore rupees, it was able to establish a distinctive reputation for its yellow and blue packaging. Court also observed that yellow and blue is a common packaging for the products that are used for sugar-free products. Like sugar-free itself is a packaging of Cadila that goes back to so many years. But what court meant to say is that this is the packaging. These are the colors which are used to describe products which are sugar-free, and advertisements made by the claim of advertisements and the expense of advertisements and sales for 6 months, which was claimed by ITC, was not enough to get its case through. And court held that it did not think that in short span of time, and particularly when Britannia alleged that the first invoice of ITC was much after than the period it claimed of 6 months, the yellow-blue combination in packaging of ITC's biscuit had become identified with ITC so as to enable ITC to prevent its use by competitors. The court did not agree to it, and the court, like I said, also added that there are good number of products in the market to use the color blue for sugarless, zero sugar or sugar-free products. So the yellow and blue combination is pretty common, and therefore Britannia is adopting a combination of colors yellow and blue for its digestive zero biscuits is quite understandable. Therefore, the court held that the get-up of yellow and blue combination of packaging did not attain distinction, and therefore was not exclusively and distinctively associated with ITC. Apart from the scathing observations on its advertisement and a sales figure and short sales span of 6 months, on which Britannia already cast a doubt by producing an invoice which was much later in point in time. The court also further held that distinctiveness is acquired in GetUp when it is not only novel but also possesses some striking feature. The court dealt with this by saying that yellow and blue combination is very common for such sugarless products, and that uh, because of all the above reasons, the case and the packaging of ITC did not fall into the category of distinctiveness. Obviously, uh, discussions were going on outside the court, and that was it for this case. Now we'll leave that case to it, and we'll come to the new. We'll come to the next slide. I'm a little short on time, so I'll start discussing cases, in a much faster way. So this is my favorite case. It's a case of Quick versus Quick Heal, where the issue of packaging and labels was discussed. So here in this case, the plaintiff is Fevikwik and the defendant is Quick Heal, Pidilite and Pomax respectively. So the plaintiff argued that they have registered and distinctive packaging of their product, which was created in-house by an employee of the plaintiff during the course of employment and constitutes an original artistic work in which a copyright subsists. Defendant, on the other hand, was not has not been using its own trademark. Packaging is registered, but has also been using the packaging which is similar to that of the plaintiffs. The plaintiff's contention was that the defendant had used every single feature of its product's packaging in its minutest details, and therefore the plaintiff had a clear-cut case of infringement and passing off and of the goodwill and reputation of plaintiff's product. If not protected, then it will result in irreparable damage. The court agreed with all the arguments of the plaintiff and granted a case in favor of plaintiff, stating that defendant's product was likely to cause confusion among the public, as the packaging of two products were identical and they were most likely to be sold side by side over a lot of counters, and their price being same, it would easily be made by the customer that that Quick Heal is a sister concern product of Fevikwik. This is one more interesting case about Red Soul trademark. In this case, it was argued by the plaintiff that the shoe with Red Soul clearly identifies plaintiff's product, distinguishing it from others. The Red Soul trademark has thus become the signature of the plaintiff. The trademark Red Soul has registrations in different jurisdictions, including India, and simultaneously it enjoys a transborder reputation by virtue of various factors. It has also got a spillover reputation in India from various other countries, as the consumer across the globe are well aware of the goodwill and reputation of the mark even before it was formally launched in India. The defendants in the suit were local shoe manufacturers, and they were selling the shoes with red sole, thereby infringing the trademark of the plaintiff. The court, after looking at the material evidence, it permanently injuncted the defendants from doing any business or dealing with footwear bearing the registered trademark of the plaintiff, which was red sole. And this was also the first instance in India where any court discussed such a feature of a mark being a well known. So this is another case where there is a comparison of trademarks Castrol Active and Lumex Active, and the court found that there is no similarity between the marks, but there is, of course, when the marks are not seen, but when the marks, if seen in isolation of trade dress, color scheme, packaging, design, layout, shape, and configuration, only then the marks are not similar. But when they are seen along with all these features, the marks obviously appear similar. Therefore, the court found that the both the marks were different, being Castrol Active and Lumex Active. But the dishonesty of the defendants lied in adopting the exact same packaging, and which made the entire case in favor of Castrol, and that's how the court stopped a defendant from using the same packaging trade dress. And although it observed in the judgment that it can still go and use the mark Lumex Active but not in its present form. So I'll take you through some global examples, very interesting ones. Who has the right to the trademark who has the right to trademark the word Apple? The Beatles or the Apple company. The Beatles came first with their music company Apple Corps, and then 8 years later, Steve Jobs introduced Apple to the world. So the two mega corporations have battled it out in courts for years. So Apple and Apple courts have agreed to a case settlement previously, but then Apple introduced iTunes, and finally, and in once and for all settlement, Apple, the iPhone company, bought out Apple Corps, as in the trademark Apple. And because Apple Corps still wanted to use the trademark in a way of settlement, Apple iPhone company licensed that trademark back to Apple Corps, and thereby this is a very unique case of trademark, which I think would feel different to all of you. So the word superhero is currently a trademark for both Marvel and DC Comics, and they vigorously pursue other comic book publishers in court who dare to use the word on their title pages. This campaign by the two comic book titans have been seen by some as trademark bullying, but so far no one has made a real effort to contest their ownership of the word superhero as a trademark. The Washington Redskins recently lost out their trademark protection. Remember, I discussed the trademarks that hurt sentiments of a particular class of citizens, which we discussed earlier in the types of trademarks. So this is a case law which directly hits that point we discussed. So the Washington Redskins lost their trademark protection for the team name because the United States Patent and Trademark Office ruled the name was disparaging of Native Americans. They don't have to change the name of the team, but they have lost the ability to prevent counterfeit Redskins merchandise from entering the country and being sold. So the team, make sure your company's trademark product name is as inoffensive as possible, right? Uh, this is a very unique case. I like it very much. The noted distiller discovered that a book cover by popular author Patrick Wensink looked an awful lot like the trademark, so they sent him a cease and desist letter. But the letter was not framed in standard threatening legalese. Instead, it was a cheerful reminder to Wensink that, as a recognized fan of Jack Daniels whiskey, he might consider changing the cover. And if he did, Jack Daniels would happily contribute financially towards such change. Wensink publicized this letter on his own website and it went viral, garnering Jack Daniels a ton of positive publicity. So this is the one other landmark case which I wanted to discuss on, again a type of a trademark which is called descriptive trademark, which we discussed earlier. So how descriptive marks are very weak marks is probably explained by the way of this judgment. So in case of Cadila versus Amul, the court ruled the descriptive word sugar-free cannot be used as a trademark and cannot be owned by anyone. The judge also ruled that Cadila Healthcare cannot be allowed to arrogate its monopoly to use expression sugar-free, since the said expression, being inherently descriptive in nature, has become a commonly used word in relation to its food and beverages. The judge also observed that sugar-free is not a coined word, and nor it is an unusual combination of words, and therefore is a commonly used expression in written as well as spoken English, and hence cannot be monopolized for use by any trade. The court also makes it clear that any descriptive word cannot be monopolized in as having secondary meaning unless that is only manner that the product can be described and no other. It was also made clear that any popular expression in line of a particular category cannot be owned by anyone, and it will not be equitable to allow a blanket injunction for use of popular expression by one party, so long as it is used as a descriptive epithet and not as a trademark. Therefore, here the court, while refusing to accept that sugar-free is a coined term having unusual connotation, the court set itself to ascertain the alleged distinctiveness by looking into the range circumference of the consuming class of the product. In the court's opinion, there was established a considerable distinctiveness of Cadilla's mark among traders, medical practitioners, and other class of India. While it may be accepted that Cadila had been successful in establishing distinctiveness of its trademark in respect of a select class of people, it still could not prove why an embargo should be placed on the defendant from absolutely using the same expression not as a trademark, but in its descriptive or laudatory sense. In view of the same, the court refused to grant an injunction to Cadila and asked Amul only to change the font size of sugar free from big to small and make Amul big and sugar free a little small, which I think after the alterations were made, the mark looked quite like this, which is in front of your screen. So Imami Limited served a legal notice to Arbaz Khan Productions for using the phrase Jandu Bam in the song Munni Badnaam Hui track of Dabang movie. The notice was sent by Imami, claiming that the production house had used its trademark without their uh, permission. So by using the brand name, it's then the notice specifically said that by using the brand name in the song without permission, the production house had violated the rights of Imami and also caused defamation and loss of reputation to Imami, and also to the damage to the product manufactured by them. So, in a very unique settlement for this case, the production house settled the case out of court with Imami, where it allowed Imami to use a certain part of the song for a certain amount of time free of cost as an advertisement from the company. Therefore, you could see in between, before several years, this part of a song Munni Badnaam Hui was being used to promote the product Jandu Balm of Imami company, which was actually the part of this unique settlement that took house between this production house and Imami Limited. And that's how Imami got the rights to use the part of song in its advertisements by the way of this settlement. So this is one more aspect which is absolutely not on the perspectives that we are discussing, but I thought to put it in front of all of you. Harpic went after Domex when Domex compared both the products in its advertisement. However, the court ruled against Harpic, claiming that the manner in which products were compared was not disparaging to Harpic, but it was actually benefiting the consumer, and it was in public interest, and for the therefore no injunction was granted, and actually the advertisement was allowed. And the point that Harpic took was that its trademark was used without permission was also not allowed by the court, citing public interest, and that public has a right to know the benefits of both the products one against the other. So this is one more case where the Delhi High Court, ruled against uh, Exotic Mile, an audio gadgets business firm, for violating the registered trademark board of Imagine Marketing Private Limited. Imagine Marketing is the owner of Trademark Boat, well-known electronic product supplier in India. So it contended that Exotic Mile had dishonestly adopted the trademark Bolt, which is phonetically and deceptively similar to Boat. It also alleged that the usage of the tagline "Unplug Yourself" by Exotic Mile was confusingly similar to its tagline "Plug into Nirvana." The class of users of the product sold by the plaintiff and the defendant is all stratas of the society, including children as well. The similarity between the two marks has not to be adjudicated by the way of precision, but the manner in which senses perceive a fact and retain it in the memory. Boat and bolt being quite phonetically similar, a consumer would not have a correct, complete, and reflection when he goes to buy the product whether the product is of boat or bolt, because of the first two alphabets of the and the last alphabet of the two words being the same. Further, the logo of two products is also similar in form of a triangle, and the tagline also uses the word plug in both so as to cause a deception. So, therefore, the court ruled in favor of Bolt and against Bolt, citing all the aspects that were discussed. Um uh, so, the Delhi High Court passed an injunction against three footwear companies located in Agra, and it was a very clear case of counterfeiting the brand Nike. And so since its adoption in 1971, Nike has been using its brand name continuously worldwide and is the registered holder of marks such as Nike and Swoosh logo worldwide. Based on the evidence and reports submitted and by the appointed local commissioner, the court noted that the defendant's adoption in usage is creating undue enrichment by creating confusion in the minds of consumers, and that's how the court ordered the defendants to pay Nike a damage of 50,000 each. So it was each. There were three defendants in this case. So, the French clothing major that is on your screens had filed an application for injunction in the Delhi court. Um, here, the defendant Suresh Kumar Sharma was selling T-shirts which was bearing the trademark of the plaintiff and was causing infringement of trademark and passing off. The court observed that the defendant had no right to use the trademark and ruled in favor of the plaintiff. So Bajaj Electricals, which is part of the Bajaj Group, filed an application, against Gaurav Bajaj, an individual who operates two retail electrical appliances store at Punjab. Uh, so Gaurav Bajaj was operating his stores under the trade names Apna Bajaj Store and Bajaj Excellent. Defendant operated a website under the domain name apnabajajstore.com, and Bajaj Electricals rightly pursued an action and stated to the court that it was using the brand since 1987. It was well-known mark, and that the defendant's expressions being used at his shops and also on the website were dishonest, and he was also causing a lot of confusion in the market, which falsely signified that the brand flowed from the Bajaj Group. So, despite several notices of the court, the defendant did not appear or reply, and all the submissions and evidences placed by the plaintiff in the court were accepted, and that's how the defendant was stopped from using the expressions Apna Bajaj Store and Bajaj Excellent along with the domain name apnabajajstore.com, even when his surname was Bajaj. But this was a clear case of the, misrepresentation in more ways than one, right? Um, this is one more case where the German sports footwear brand filed an application at the court in New Delhi for injunction against Ludhiana-based business proprietor for using its trademarks Puma. So Puma also stated that he was misrepresenting and deriving unfair advantage by using the well-known mark Puma on his products. In this case, also the defendant did not appear, nor did he file a reply, and therefore the court passed an order in favor of the plaintiff and also granted damages to the plaintiff from the defendant. So this is a very interesting case. It's again involves transport reputation and a lot of other interesting aspects. Plaintiff is a well-known designer and seller of fashionable clothing, having over 4,000 outlets worldwide, along with online presence in 21 countries. The trademark H&M was adopted by the plaintiffs in early 1970. The plaintiff secured the first registration in the state trademark in UK in 1985, whereas it was registered in India in the year 2005. The plaintiff claimed prior and exclusive rights in their trademark and contended that the defendants had represented the letters H and M in a manner similar to that of the plaintiffs and used the color combination of red and white as well, thus infringing the plaintiff's rights in their mark. So, on the other hand, HM Mega Brands, an Indian company engaged in the business of marketing, supplying, and selling of garments, adopted the mark HM in the year 2011 and applied for registration in 2014. In its defense, it argued that the adoption of mark was honest and the same was derived from its initials of its directors' names. So, in addition to that, it also claimed that the use of mega brands in the mark sufficiently differentiated their goods from those of the plaintiff, and their primary contention was that the plaintiffs had not entered the Indian market in 2011, which was the year of the adoption of defendant's mark, and thus had not acquired any reputation with respect to the trademark in India. So, while analyzing this particular defense plea raised by the defendant, the court observed that the similarity between the two marks, that any consumer familiar with the brand H and M of the plaintiff, upon seeing defendant's brand and seeing it being described as mega brand, may associate the goods of the plaintiff with the defendant. Also, sorry, defendant with the plaintiff. It also noted that in addition of mega brands to alphabetical letters, HM in defendant's mark creates an impression of association between both the parties and reinforces the impression in the minds of the consumer that the businesses of the rival parties are related to each other. As regards the generic nature of H&M or HM, the court held that the said trademarks were not publicly injurious to the trade or business of the plaintiffs or the defendants. The trademark was the state trademark was alien to the trade of both the parties, which was related to fashion clothing and had been admittedly adopted by the plaintiffs much prior to the defendants. As far as the question of plaintiffs' presence in India at the time of adoption of defendants' mark was concerned, the court noted that for an international mark to have reputation or goodwill in India, setting up of a shop or sale in India is no longer a necessity, and the introduction of web-based sales has increased the familiarity of international marks and brands in the Indian market. Thus, the court concurred with the plaintiff's claim of prior rights in the marks and concluded the case in favor of the plaintiff. The grant of image trademark to Taj Palace Hotel confers exclusive rights to exercise the rights of ownership. This gives a degree of immunity from rivalry in the market. It may facilitate conduct by the IP owner to that would add to its valuation, goodwill, and reputation in the general business sense. This also paves way for registering non-traditional trademarks, which the owner feels are really important and beneficial to the business character of the company in the market. So this is where India is today. It is at the 48th position. It was 81 in 2015. This is because of number of steps that the current establishment has taken, and thereby increasing the output and input innovation index, and also phenomenal success of apps like Arogya Setu and Bhim UPI are classic examples of nation's adoption of ICT-based services during the current situation. So uh, uh, this is an example which I like because Rolls-Royce trademark was bought out by BMW, and the physical assets of Rolls-Royce were bought out by Volkswagen, and experts have been at loggerheads debating that BMW actually got a better deal because it got a trademark. And in light of the ice cream example that I discussed with you, I think BMW got a so uh, according to the new rule, although you all of you must be aware of it, but still I'll go and say this. According to the new rule, a trademark owner can file an application for TMM with a request made to registrar for declaring the mark to be well known. A well known trademark has been vouchsafed with extraordinary protection and safeguards against passing off and infringement of such trademarks. The registrar shall, while determining whether a trademark is a well known trademark, takes into account all the facts which he considers relevant for determining a trademark as a well known trademark, including the following factors. The trademark is well known to public in India. The number of actual potential consumers of goods or services, the duration, extent, and geographical area use, and the circle dealing of entry channels of those goods or services. So, before concluding, I will obviously stress on search reports. Trademark searching is an important first step in any trademark registration or brand launch strategy, as it enables companies to avoid adopting brands that infringe third-party trademark rights. The attempted registration of such names can be costly and time-consuming, at, as it will as it will invariably result in other party raising an opposition to the chosen mark. So some advantages of the searches that I would like to put in front of you are, one can avoid the costs of business distraction associated with the forced rebranding, providing the time and flexibility to amend the mark before launching the goods and services. and prevention from spending money and resources on a mark that might not be available or might be relatively refused under Section 11. So the first to use system recognizes an unregistered brand being used as a trademark and confers rights on the owner, uh, although these are typically weaker than the equivalent registered rights. So first to file systems vary in their application. China stands out as a country that takes a hard line stance. The first person to register a brand obtains the right regardless of the creation by a different business owner. Yeah, so a first to file does not always mean that the first registrant will acquire inarguable sole right. So most first to file countries will allow applications on the basis of goodwill acquired by the prior users of a brand. And but there are other terms and conditions that are worth considering. So India is a very good example of first to use as per the Manikchand case, of which is a 2005 Supreme Court judgment. If any of you is interested in understanding the concept of prior use versus first to file, and India respects the first to use, and it's always above all of the other aspects as far as the use of a trademark is concerned, and as far as the supreme ownership of a trademark is to be decided, first to use works in India. So I think I have completed my presentation. I thank all of you for joining in here and listening to me patiently. You have been very patient listeners, and I hope all of you have benefited from this presentation. Thank you. I give the floor back to Sudisha.
Thank you. I just wanted to ask, does anybody have any questions that they would like to ask Nakul?
Okay.
I don't think.
Okay.
Okay.
Okay. Thank you. Thank
Thank
you,
you so
everyone.
much. Thank you.
Yeah. Bye.
Bye bye.
Thank you. Thank you so much.
Thanks. Bye.